Okay. And we'll make this video available to you all later on our website, washoucourts.com/law library. And I'll go ahead and put those websites into the chat. If you have any questions, go ahead and please type them into the Q&A feature. You'll find that at the bottom of your screen. If you feel more comfortable to ask a question that's not attached to your name, go ahead and use the anonymous function. And if you see a question that you would like to know the answer to as well, there is the option to give it a thumbs up or to upvote it, and we'll know that multiple people are interested in knowing the answer to that question. I also wanted to let you guys know that Nevada Legal Services also has a YouTube channel that they have previously uploaded other live streams on the eviction process in Nevada. So you might be interested to visit that website as well. And again, I'll be putting all these websites into the chat function. So keep an eye out for that. And without further ado, I'm going to go ahead and introduce Rae Gertkin. She's the directing attorney for the Northern Offices of Nevada Legal Services. And welcome, Rae. Thank you for doing this presentation for us.
Thank you, Natalie. Thank you so much for having me. I'm more than happy to do this and get as much information out to everyone as I can. As Natalie said, I am Rae Gertkin. I am the directing attorney of the Northern Offices of Nevada Legal Services. We have offices in Reno, Carson City, Yerington, and Elko. So we do serve the entire state. We also have an office in Las Vegas, but I am the managing attorney of our northern offices. So I will go ahead and get started. And as Natalie said, please feel free to ask some questions and I'll be more than happy to answer them, I believe, after the presentation. All right. So as Natalie said, this will be a presentation on the phasing out of the eviction moratorium. Just as an initial disclaimer, this is only for educational purposes and I am not giving any legal advice regarding this information in this class. All right, so just as a brief overview, I will be talking about Directive 25, which is the phase out of the eviction moratorium and the timelines involved. And then I will go through what happens after the moratorium is lifted and do an overview of the summary eviction process in Nevada until essentially I run out of time. I can probably talk about this for longer, so but I do want to make sure I leave time for questions. So we'll get through as much as we can. So the governor issued Directive 25 on June 25th. Just as a preliminary matter, one of the big takeaways on how the timelines are sort of enacted depends on the type of process. The distinction is being made between summary eviction, which is for most residential tenancies of dwelling units, and that's in NRS 40.253 and 40.254. Commercial evictions for non-payment of rent, so businesses. And then non-summary or formal or plenary. I just use a non-summary here to cover sort of the more formal process for eviction, which is just your normal civil process. And that's for mobile home park evictions and evictions after sale or foreclosure. So we're going to start with June 25th. One of the things that Directive 25 specifically said was that public accommodations can begin evictions and lockouts on June 25th, the day the moratorium Directive 25 was enacted. But I do want to be clear that the directive specifically references NRS 651, which is the public accommodations statute. But mobile home residents may be tenants under NRS 118A, and then Chapter 118A is the Residential Landlord Tenant Act. If a mobile home resident, I'm sorry, I meant motel, not mobile home there. That should be motel resident. If a motel resident has lived in the motel for 30 days or manifested an intent to remain for a longer period of time, so 30 days or more, then they are tenants. They are tenants entitled to protection under NRS 118A and cannot be locked out. They are entitled to the same notice requirements as all other residents of apartments, regular dwellings, all other tenants. So I just want to make clear that when we're talking about NRS 651, we are talking about guests at hotels, short-term guests, people who are here for the weekend or, just 1 week or a very short period of time. Somebody who moves all of their belongings into a motel just because they pay rent weekly does not mean that they are not tenants under Nevada law. So beginning July 1st, commercial evictions could start. So businesses could begin receiving eviction notices as of July 1. Also starting July 1st for mobile home parks can start issuing eviction notices for cause, but not for non-payment of rent. So this is only for things that violate NRS 118B 200, some of the grounds for cause evictions for mobile home park tenancies. Also, post-sale and foreclosure evictions can begin. So these are your categories of the non-summary eviction process. So things that require a formal eviction complaint will be able to start July 1st. And this also includes any evictions that were in process as of March 30th when Directive 8 was enacted. So if a landlord filed a complaint against a tenant in a mobile home park or after a sale that was stayed by Directive 8, those evictions can begin as of July 1st. But again, this does not include non-payment of rent evictions, but other cause evictions or post-sale and foreclosure evictions. The next time frame that we're dealing with then is August 1st. And August 1st starts some of the summary eviction or residential landlord tenant eviction processes. So for cause evictions or evictions after a lease expires, if the lease expired during this period, can begin August 1st, not for non-payment of rent. We'll get into that. This also includes mobile home parks for non-payment of rent. So if you are a mobile home park tenant and have not been paying rent because of the issues surrounding coronavirus, then non-payment of rent evictions can start August 1st for mobile home park tenancies, and that's that more formal process. But summary evictions for anything other than non-payment of rent or no cause can begin August 1st. And the directive does have language that indicates that this is not a substitute for a no cause or payment of rent eviction. This is really for lease violations, nuisance notices that don't involve failing to pay rent or substitute for a no cause notice. And this also then includes any evictions that were in process before March 30th. So if an eviction action was pending before a court that was stayed by Directive 8, again, this is for formal evictions. Now this can start with non-payment of rent if the landlord had filed a complaint in court to evict a tenant prior to March 30th. And then this would also then include summary eviction. So summary eviction actions where the tenant filed the tenant's affidavit and it was actually pending before a court can start for cause evictions August 1st. Then September 1st is our final deadline. So this is basically then everything. The final eviction that is allowed as of September 1st are non-payment of rent evictions and no cause evictions for summary eviction. So all residential landlord-tenant evictions can then begin September 1st. And this also, of course, includes any case that was pending in court prior to March 30th would be able to begin or reinitiate essentially September 1st, including lockout orders. So if a lockout order was pending, then this includes anything that was stayed by the court can then start on these timelines, with the last one being September 1st. So just a note about the notices and late fees. So late fees are still prohibited. Late fees from March 30th through July 31st or August 31st, depending on where you're living, can never be charged. So those late fees did not accrue March 30th through July 1st for mobile home parks or August 31st for residential tenancies. The other thing that the eviction moratorium, I should say, was eviction and foreclosure moratorium, because the other thing that the eviction moratorium or Directive 8 and Directive 25 stayed were foreclosures. Foreclosures are still stayed. through September 1st, but the one caveat is that interest on mortgages can begin again. So there was a prohibition on interest accruing like late fees, but the Directive 25 did allow interest on mortgages to accrue, but the foreclosure moratorium is still in place. Directive 25 also makes clear that any eviction notices served prior to and during the moratorium are void. And we did talk before about evictions in process or pending before a court. So these are any eviction notices that were issued during the moratorium are void, and except if the notice was issued prior to the enactment of Directive 8 and something was filed in the court. But if nothing was filed in the court or an eviction notice was issued during the moratorium period, all of those notices are void and must be reissued or served. So essentially, landlords need to begin again unless it was already in court and simply stayed by Directive 8. And I would argue this includes like if a landlord was alleging an emergency exception, but it didn't meet the standard, those now too are void. Everything should be void, except, as I said, if it was filed prior to March 30th. All right, so what does this mean? We've kind of talked about it. Depending on what the date is, it means that landlords can issue eviction notices or, reinitiate court actions that were stayed by whatever date was included in the moratorium. So if a lockout order might have been issued, then that lockout order can be executed on the date allowed by the Directive 25. So if there was a lockout for, say, a lease violation and a summary eviction action that was entered, when Directive 8 was implemented, that can begin August 1st. But it does mean new notices have to be issued or notices have to be served. All right, so, a lot of people these days have been struggling to pay rent because, as we all have been reading in the news, unemployment claims are still not getting paid. While businesses might still be opened, they're not necessarily at full capacity. And so, part of the issues and why the moratorium was necessary was to prevent mass eviction and disbursement of people during this pandemic. But it needs to be made clear, I think, that rent is still owed. This was not rent forgiveness. This was simply a stay of evictions to give everybody some breathing space during this pandemic. So if you can pay rent, pay rent. It is still in effect. Obviously, the moratorium, depending on where you're at and sort of the timeline, landlords should not be issuing notices in violation of Directive 25. And Directive 25 has indicated that a landlord who violates the directive could be subject to an unfair and deceptive trade practice claim. So the Attorney General's office is still taking complaints and has been through the moratorium process. If a landlord locks a tenant out without going through the court process, this is unlawful. A tenant may be able to file a verified complaint for illegal lockout, and those are being heard. Those are part of the court's emergency exceptions. Those types of cases are continuing to be heard in court. And then finally, what Directive 8 did as well, but what Directive 25 continues is this encouragement for landlords and tenants to work together. It is not mandatory, but to that end, they also attached a promissory, or the governor attached a promissory note and lease addendum that is sort of I call it a model for an agreement between a landlord and tenant for the tenant to pay back whatever rent might not have been paid during the moratorium period over a lengthy period of time. As I said, the promissory note is not mandatory. It is simply an encouragement for landlords and tenants to work together, but also to acknowledge that there does need to be time for tenants to sort of repay some of the rent they might not have been able to if they're now getting unemployment benefits or now have gone back to work. The landlord does agree not to evict for past due rent, but eviction is allowed for violation of the agreement moving forward. And then finally, if the tenant has to or does receive rental assistance, that rental assistance must be turned over to the landlord. And that includes, just an FYI, the CARES Act included a lot of money for rental assistance. I know the City of Reno's housing department has already been taking applications for rent. And so anybody who might be suffering, who was not able to pay rent, can apply for financial assistance. In the rural areas, it's the Nevada Rural Housing Authority that is taking applications, I believe. And the United Way also dispersed funds to a lot of nonprofits when the Attorney General authorized the payment for rental assistance. That was a few months ago, so I don't know if there's any money left through that program, but there are still agencies who potentially have money available for rental assistance. So you can contact the City of Reno. I know Las Vegas and Clark County are doing very similar things. So, if somebody isn't really living anywhere in the state of Nevada, there's likely some rental assistance program that is taking applications. We also have a coronavirus resource guide on our website that you can also access. So one of the things that was included in Directive 8 was an emergency exception. It was essentially if a tenant was committing crime, significant property damage, or seriously endangering other tenants, that they could still be evicted. So there was still an emergency exception through the moratorium period, but as of August 1st, any nuisance notice will be allowed to be issued. Until then, there's still the emergency exception. All right, so that's pretty much an overview of the moratorium, Directives 8 and Directive 25, as they currently stand. But what happens when, now we're July 1st, mobile home parks can issue eviction notices. As of August 1st, tenants can receive lease violation notices. So what happens? So basically it's the eviction process. I am now going to go through a little bit of the summary eviction process in Nevada. So summary eviction is basically laid out in NRS 40.253 and 40.254. The 40.253 governs the non-payment of rent evictions and the hearing process, and 40.254 has the other than non-payment of rent evictions included in that statute, and it cross-references the summary eviction statute, which is technically 40.253. So that includes a lot of different types of eviction notices. You have your 7-day pay rent or quit notice, your 5-day lease violation notice, your 3-day nuisance notice, and then your no cause notices. And then service of eviction notices is covered in 40.280, and notices must be served by a sheriff, constable, or licensed process server, or the agent of an attorney who represents the landlord. The notice has to be delivered to the tenant personally, or if the tenant is absent, leaving a copy with a person of suitable age and discretion and mailing a copy to the tenant, or by posting a copy in a conspicuous place on the leased property and mailing a copy to the tenant. So that starts the eviction process with service of the eviction notice. Now, whether or not one notice is required or two depends on the type of notice. And really, the main one that we're going to address where only one notice is required is the 7-day pay rent or quit notice, because that is an unlawful detainer notice. All of the other notices I'm going to talk about, including lease violation notices, nuisance notices, and the no cause notices, do require the unlawful detainer notice to begin the eviction process. So for general defenses, across the board, again, Nevada Legal Services represents tenants, and so I'm mostly going to talk about some of the defenses that tenants can raise for eviction notices. So some of the arguments that we often make are that notice is improper, because proper notice is a jurisdictional prerequisite for an eviction action, specifically for summary eviction, because it's created by statute. So just, when the notices are issued to tenants by landlords, the notice statutes have to be complied with. So that means if the notice has not expired and the unlawful detainer notice was issued early, that could be a basis to contest the eviction. If the notice does not properly advise the tenant of his or her right to file the tenant's affidavit to contest the eviction, if the improper party is named, or if there is incorrect language on what happens if the tenant fails to respond. So those are all requirements that are contained in 40.253 or potentially 40.254. And again, one of the defenses that tenants have raised and we have raised during the moratorium is that the notice does not comply with the emergency exception and therefore is a violation of either the CARES Act or Directive 8 or 25. All right, so if let's say it's September 1st and you have not been able to pay rent, you cannot come to an agreement with your landlord to pay the rent, what's going to happen is the landlord will likely issue a 7-day notice to pay rent or quit. The notice itself has to contain all of the required language pursuant to NRS 40.253. And that includes the amount of rent owed, the proper parties, the right to contest, that the landlord is prohibited from locking the tenant out, and that if the tenant doesn't respond, they can be removed 24 hours after they receive a copy of the order without further notice. The tenant, though, has 7 judicial days from the date of service of the notice to file a tenant's affidavit if the tenant wishes to contest the eviction. If the tenant does not respond, the landlord can simply ask the court for a lockout order without a hearing. So, and that's no further notice. If the tenant does not respond within that 7 judicial day time period, there can be a lockout order issued without further notice to the tenant. Now, before the tenant can be removed, though, the sheriff will serve the lockout order on the tenant, and then 24 to 48 hours, I'm sorry, I think it's 24 to 36 hours, I apologize. I think it's 24 to 36 hours after receipt of the order. Some of the defenses to a non-payment of rent notice include that the tenant has actually paid the rent. If there's a dispute as to the amount owed and the tenant paid what they believe they owed, they paid the rent. Unless, of course, there is no actual dispute. The landlord and tenant obviously can enter into an agreement. And if the tenant has not violated the agreement, then that would not be a basis to evict the tenant for non-payment of rent. Landlords cannot refuse to accept payment of rent and then turn around and evict a tenant for not paying that rent. And the tenant can properly withhold rent for violations of habitability or essential services statutes. And that's contained in Chapter 118A. And the process to properly withhold rent includes required prior written notice. So the tenant must notify the landlord of the problem, unless the landlord is notified by code enforcement or maybe a housing authority. If they've received any sort of written notice, that will suffice, but essentially some sort of written notice has to precede a tenant withholding rent. And then again, as I said before, Directive 25 prohibits late fees from March 30th through August 31st or July 31st, depending on the type of housing. So landlords can never evict tenants for or collect from tenants the late fees during that time period. So that money cannot be included in a non-payment of rent notice. All right, so moving on to lease violation notices. This is generally a 5-day lease violation notice followed by a 5-day unlawful detainer notice. I say generally 5-day because subsidized housing does require a different notice period. So if you are, say, in a HUD subsidized housing unit, you might be entitled to a 30-day notice. So just keep that in mind. And then obviously for mobile home park tenancies, this will be different. First of all, there's a 10-day pay rent notice. And then there are other cause notices under NRS 118B. But for summary eviction, generally speaking, we're looking at a 5-day lease violation notice. And then if the tenant does not cure the lease violation or vacate during that 5-day period, they are then, the landlord can then consider them a holdover and issue the 5-day unlawful detainer notice, which begins the eviction process. So the 5-day lease violation notice must describe the lease violation. It also has to, and then the 5-day unlawful detainer notice also has to state the proper court and parties, advise the tenant of his or her right to contest the notice by filing a tenant's affidavit, advise the tenant if a court determines the tenant is guilty of the unlawful detainer, they can be locked out. Again, that should be 24 to 36 hours. And advise, in this time, because it's under 40.254, the notice has to advise the tenant of his or her right to request a 10-day stay of eviction pursuant to 70.010. Then the tenant has 5 judicial days from the date the unlawful detainer notice is served to contest the eviction by filing a tenant's affidavit. Some defenses are that the tenant cured the lease violation, the tenant did not violate the lease, or they could argue that the violation was something that wasn't material, was, something that essentially shouldn't result in the harmful remedy of eviction. And the next notice we're going to be talking about are nuisance notices. So for nuisance notices, this is a 3-day notice. This again must be followed by the 5-day unlawful detainer notice. The 3-day notice has to allege how the tenant is a nuisance. And then the 5-day unlawful detainer notice must include all of that statutory language that I talked about in the lease violation notice. And that includes things like requesting the stay, that they will be locked out if they don't respond, where to respond, the proper court to respond in. The tenant then has 5 judicial days from the date the unlawful detainer notice is served to contest the eviction again by filing the tenant's affidavit. And some of the defenses to the tenant's affidavit include that the tenant is not a nuisance. Nuisance is defined in 40.2514 as conduct or an ongoing condition which constitutes an unreasonable obstruction to the free use of property and causes injury or damage to other tenants or occupants of that property or adjacent buildings or structures. Just coming from our perspective, it's most landlords, I will say, in nuisance notices do not meet this definition. So, a nuisance is pretty high standard in terms of, what you're considering a nuisance. Not to say that there are no nuisances, but the nuisance notice itself has to specifically allege how the tenant is a nuisance. The tenant does have the right to abate a nuisance and can dispute the nuisance because, again, the tenant just has to raise a legal defense in the hearing to defeat a summary eviction action. And then finally, the no cause notice. And these, again, this would be September 1st for a no cause notice, but any no cause notice must be followed again by the 5-day unlawful detainer notice. The no cause notice must advise the tenant of his or her right to request an additional 30 days to move due to age or disability. And the 5-day unlawful detainer notice again must contain all that statutorily required language. The tenant has 5 judicial days from the date the unlawful detainer notice is served to contest the eviction by filing a tenant's affidavit. And then some of the no cause notice defenses, mainly if the notice itself does not advise the tenant of their right to request the additional 30 days due to age or disability, that would be the main one. But landlords can also not issue no cause notices to tenants in retaliation for, say, complaining about a habitability violation. And also landlords cannot discriminate against tenants and try to ask them to move, even not alleging notice, if it's for a discriminatory reason. And then finally, obviously, if the lease has not expired, the lease would generally require cause. You can have month-to-month leases for sure, and those can be terminated on 30-day notice. But if it's a written term lease agreement, generally speaking, a no cause notice isn't going to cut it. And then usually tenants in some type of subsidized housing cannot be evicted without cause. So if you're in a HUD subsidized or a low-income housing tax credit property or some other subsidized housing, generally speaking, you must, landlords must allege cause to evict tenants. But that does it. I actually got through that a lot faster than I thought I would. So Natalie, if there are any questions, I'd be more than happy to answer them now.
Yeah, we do have a few questions. One is it legal for a landlord to include late fees into the payment plan? Is it legal for a landlord to include late fees into the payment plan?
No, so the landlord can never charge late fees for the moratorium period. So if there were late fees, I will say if there were late fees owed like in March, because it started in March. So if there are late fees owed prior to March, then that is potentially still owed. But no, if you're talking late fees from March 30th through September 1st, say, no, those can never be collected.
Okay, we do have another one. So a landlord cannot just put on a tenant's door, it must be served. So I'm assuming that's the eviction notice. It cannot just be put on the tenant's door, it must be served.
So again, under 40.280, the landlord is required to first attempt personal service. So the sheriff will come by, knock on your door, but if you're not home, then yes, it can be posted on the door and then mailed. It has to be both, posted and mailed. But no, they do have to attempt personal service. But if you're not home, then the process server or sheriff can post that notice on your door and then mail it to you.
Okay, we have had this question a few times. We are recording this webinar and it will be made available on the law library's website, and we can certainly give Nevada Legal Services a copy of this to share on their YouTube. They also have other eviction live streams on their YouTube channel as well, which I have in the chat. Here's another question. Is interfering with quiet enjoyment of property considered a nuisance?
That might be a difficult question. Well, I'll say this. So certainly most leases have what's called the implied covenant of quiet enjoyment, where a tenant is supposed to be able to enjoy their residence without interference. So in that sense, it's not technically the same thing as a nuisance. So if your neighbor, though, is causing a nuisance, let's say your neighbor has their dog barking at all hours, won't control the dog, or is playing loud music from 2 a.m. to 6 a.m. every night and will not stop. If that's interfering with your quiet enjoyment, it's a hard argument, but essentially, I guess a nuisance could cause an interference with your quiet enjoyment, but it's really, the tenants there is implied in lease agreements that tenants will be able to enjoy their property without interference.
Okay, we have another question. Are there any legal differences between commercial tenants and residential tenants?
Yes. So commercial tenancies actually have their own statute. That's 118C. There's also a separate summary eviction statute for commercial tenancies in Chapter 40. It's actually a whole separate statutory scheme. It is very similar, but there are differences. They are essentially two different sets of laws.
Okay. I got another question here. So it missed. So I'm sorry. So if missed, be posted by sheriff only if landlord attempt in person failed. Oh, I think maybe, so if the notice.
Yes.
Yes.
Yeah, technically speaking, under 40.280, it is supposed to have been attempted personally first. But if that is not possible, then yes, it can be posted.
Can you be evicted for smoking marijuana in a non-smoking home if the tenant has a medical marijuana award? Could that be cause? Or would that be cause?
So this might be too specific of a question. I think I would need a lot more facts and circumstances. But I think it depends on what the lease says in terms of, or what the rules are with regard to smoking in the unit. But again, I think that's too specific. I'm not going to be able to answer that really without more.
Okay. If a client is served an eviction notice during a hospital stay, do they have any legal backing to fight the eviction?
Well, I think it depends. I think certainly if they're So if the eviction notice was served and then a lockout order issued, I think that the tenant could try to argue to set the eviction aside to request a hearing before a judge. But that does require that there actually be a legal defense to the eviction. So I think it really depends on whether or not there's an underlying legal defense, but certainly not being at home and being in the hospital when the notice was served could give you cause to ask that the judge set a hearing, even if the lockout order was issued.
Okay, and forgive me, Ray, because I believe we've talked about this, but are we making the PowerPoint available to people after this presentation, or will it just be the recording?
I can certainly make I know we made the PowerPoint, one of the other eviction moratorium PowerPoints. I think the YouTube one is actually on our website right now.
Great.
So I can certainly do that. I might make some of the changes I noticed that were wrong. So forgive me if it takes me a day or two to get that up, but I can certainly put that on our website, and it would be in our Know Your Rights housing page. There's a forms page and then a tenants rights page. I believe I put it on the tenants rights page.
Great, and I did include that link into the chat discussion if other people are interested to go there now. Okay, we got a question. Can landlords refuse partial payments of what is owed, or do they have to accept all payments?
So landlords are not required to accept partial payments. Even if you pay a partial payment, that would not necessarily be considered payment in full. So I think I guess I could just say no. Landlords are not required to accept partial payments, but again, even if you make a partial payment, that's not going to stop anything, essentially.
Okay. That's all the questions we have. Unless anybody has any further questions, please feel free to type them. We are here until 4:30, so as long as we have questions to keep answering. Again, just to let everybody know. Oh, okay. Thank you. Yes, if you visit our website, the washoecourts.com/law library, again, that's in the chat. You should see when we post it. We're hoping to have it done within the next few days, next week by the latest, for sure. And then I'm sure it sounds like Nevada Legal Services already has some of this information up on their page. And again, that is included into the chat function. I will tell you, as we do have a program called Lawyer in the Library for general law questions every Wednesday. You can sign up for that program. We are holding it virtually via Zoom if you guys are interested in that. It is wide open currently right now, so you're welcome to sign up for that on our website. Okay, we got another question. Is there a way to look up if your property is backed by a federal mortgage? Aren't those protected under the CARES Act?
Yes, they are, and there is a way. The CARES Act does technically right now expire July 25th. So technically the September 1st date is a little bit better than the CARES Act right now, but you are still protected in a federally backed home. So you can look this up. Actually, ProPublica has a COVID-19 eviction site. That's projects.propublica.org. I think it's /COVID/evictions. When you go to projects.propublica.org, you should be able to find it fairly easily, but you can just put in your address and it will actually show whether or not the landlord, they have found whether or not the landlord receives any sort of federal backing. The other thing is there are Fannie Mae and Freddie Mac sites. I'm not really sure what information is required if you just can type in an address or not. But both of those have information, loan lookups to see whether or not the loan is subsidized by Freddie or Fannie. Again, it's been a while since I looked at those, so I'm not sure if tenants would be able to, but certainly that projects.propublica.org would be able to.
Do you have another question? If a client gets an eviction for a lockout, is it best to tell them to get their things out right away or contact you guys first?
Well, that's interesting because we certainly don't want people to unnecessarily leave their items in the home and then not be able to get them. But at the same time, if they get that lockout order, remember the sheriff serves the lockout order, but then can't actually execute the lockout until 24 to 36 hours after that. That window is very important. That window could mean stopping the eviction versus having the eviction happen and then having to attack it after you've already been locked out. So it is kind of hard because I certainly don't want someone to be evicted while they're sitting in my office. But at the same time, it is important if somebody receives a lockout order at, let's say, 10 a.m. on a Tuesday, they can't be locked out until 10 a.m. on Wednesday. So there is that 24-hour time period where they can come see us, or they can file an appeal or a motion to set aside or stay. There are some things that can be done in that 24-hour window, but that's also the only 24 hours they might have to get their essential items together to essentially, have them if they do get locked out. So it is kind of a balancing act, but that 24 hours honestly can be key in terms of getting something filed with the court to potentially stop the lockout before it happens. Now, if somebody got the lockout order on Tuesday and then they're coming to see us on Wednesday, that's going to be too late. I would say get your essential items together and be prepared. Because it's just, if it can happen at any minute, that's not really enough time for us to do anything. And, if you're locked out, that doesn't mean that's the end of the world. We can ask the court, like I said, we can file a motion to set aside the eviction, or the tenant can file a motion to set aside the eviction to try to argue if they didn't get a hearing, or, potentially you can file a motion to stay in most cases to try to get additional time to move to. But I think it really does depend on the kind of the situation the client is in. If it's really important that they have their stuff, or if they get to us in enough time that there might be something that they can file the day before the lockout is to occur. But do remember, there was a change in the law last year that tenants do have 5 days after a lockout now, where the landlord has to let them have access to get essential personal items, including clothes, medicine, items for children, things like that.
Somebody sent me a direct question. Can a landlord take personal property as security for the promissory note for back rent?
Absolutely not. A landlord can never hold your personal property for rent, ever.
I have another question. If their things get locked in, if their things get locked in, then can they get their things afterwards, or are their belongings seized?
So no, so a landlord does have a duty under Chapter 118A to safekeep a tenant's property for 30 days. So 30 days after a tenant vacates or is locked out of the unit, the landlord has to keep that property safe. Within 5 days, the tenant does have the opportunity to get any essential personal items. And if the landlord does not provide those essential personal items or access to get them, the tenant can file a verified complaint like you would for an illegal lockout. So within 5 days, the tenant can file that verified complaint and potentially get $2,500 in damages from the landlord. Notwithstanding that 5-day period, though, the landlord does then have to safekeep the property for 30 days. That could mean that the landlord does put it into storage, and the landlord can charge you for storage before they let you get your property back. So while the landlord cannot hold the property for rent, they can hold the property for storage costs if they did put the items into storage, and that includes the moving inventory and inventory costs. So if they had somebody pack up all your stuff and put it in a storage unit, you would have to pay for that.
Okay, I think I have a follow-up question to that. So even motels, when stay has been longer than 30 days?
I would say yes. After the 30-day period, I mean, you technically only get the 30-day period. The landlord can tell you that they're going to destroy your property if you don't come get it in that 30-day period.
Okay. Do we have any more questions? I do see your question from Colo 8. We'll certainly try and get this recording to you as fast as possible. If you direct message me your email address, that'd be useful. Is there any other questions from any of the attendees? I think we're coming to an end. Again, we're going to try and get this recording out as soon as possible. If we do get it by this end of this evening, it will be on our website. Also, again, you can find this information on Nevada Legal Services website. I did put that into the chat. We can go ahead and do that again. And if there isn't, oh, we got another question. So how many days do they have before they can change locks? When an eviction notice is given, how long can a resident stay in the place before locks are allowed to be changed, i.e. locked out?
So it depends obviously on the type of notice you get. So as I said, the 7-day pay rent or quit notice, it's 7 judicial days. And then if the tenant does not file an affidavit on the 7th judicial day, the landlord can go seek on that 8th day a lockout order from the court. That will generally be granted that day. The sheriff can then, the sheriff's going to serve the notice, the lockout order. So if the sheriff gets the lockout order the next day, they can post it, whatever day they get it, they can post it, they can serve you. You then have 24 hours from the time you get that lockout order before the sheriff will come back and change the locks.
Okay, we have another question sent in the chat. If someone is unable to pay the landlord, is there any assistance for the actual landlord since they might still be paying mortgage?
There's mortgage relief programs. We're talking a forbearance. I'm not aware of any financial support for helping to pay a mortgage right now. If the tenant does apply for the CARES Act rental assistance, then that would be paid to the landlord. But the tenant and landlord would essentially have to agree that the landlord would take that money for rent. But I'm not aware of any mortgage assistance programs to help pay the mortgage, other than, especially in federally backed loans, they all have forbearance programs right now. If a landlord, if a property owner does enter into a forbearance plan, it cannot be negatively reported on their credit. And there are, especially if you have an FHA loan, there is a process called a partial claim where you can get essentially it's a loan, a non-interest bearing loan to cover any arrearages, and it gets put on the back end as like a balloon payment. So if you can now make your regular mortgage payments, or it could be included with a mortgage modification. So other than your normal like mortgage waterfall, forbearance, modification, partial claim, that sort of thing, I'm not aware of any direct financial assistance unless it goes through a tenant's base program.
Okay, we got a few more questions. What is typically the turnaround time from reaching out to NLS to the support available? 5 days seems very quick to get all matters in order.
Yes. So generally speaking, it depends on where you're at in the process. Because of course, if it's an emergency, we take emergencies on that basis. But essentially, we do try to get people somebody will at least call you back within 24 to 48 hours. When your appointment might be with an attorney could be within that time frame. But again, we're pretty well versed in the eviction process. So generally speaking, unless, like I said, you've got that 5-day unlawful detainer notice, you're on your 4th day, we can certainly make accommodations. But again, if you've gotten the lease violation notice that predated the 5-day, you've got a lot longer than the 5 days. So, it just depends on the situation. But we do, if you leave us a message, if you do online intake, we actually, our online intake system is up and running. You can access that on our website as well. We will reach out within 24 hours, usually, no later than 48 hours. But essentially, I can't guarantee when your appointment with the attorney will be, but that will just depend on the circumstances of your case.
Okay. Another question. I thought it was 24 hours from the time the deputies posted the 24-hour notice, not when the tenant got it. Could you please clarify?
Yeah, okay, sorry. Service is deemed complete when it's posted, yes. If the tenant was personally served, then that would be the time when it would run. But if it was posted, then yes, we're talking time of service, which is deemed when the tenant received it. Or I should say that's, the tenant is essentially deemed to have received it when it was served. However it was served, posted, personally served, whichever way.
Okay. Just wait to see if we get any more questions. We have a lot of questions related to the recording. Depends how quickly our IT can turn this around. Hopefully we can get it out tonight to everybody on our website. If not, hopefully in the next few days. So, okay, if there is no further questions, is there anything you'd like to close out with, Ray?
No, other than I definitely, if you are a tenant and you are in a situation that you think we might be able to help with, please feel free to give us a call. I have all of our phone numbers up there because you can call any of our local offices. We've been talking a lot about our website, and certainly our website not only has information, there are some self-help forms, but also there's that online intake application process that you can fill out, and we will again screen those within 24 to 48 hours and see if you qualify for our services.
Yeah, and it looks like you do have your phone number on the slide right there, 775-284-3491.
Yes. But anybody, feel free to give us a call if you feel like you have a question that I either didn't answer or I said I couldn't answer it. Please feel free to give us a call.
All right, well, thank you everybody for participating and being able to join us today for this class. And thank you again, Nevada Legal Services, for partnering with us and taking the time to do this presentation.
No problem. Thank you again for inviting me.
Yeah. All right, good evening, everybody. Have a great night.